It's an argument that I think a lot of us have been expecting, that I think the conservatives have been previewing for, a few years now. And the argument is basically that, the Constitution does not protect a right to abortion, that the Supreme Court erred in 1973 when it recognized under the Due Process Clause of the 14th Amendment a right for pregnant individuals, pregnant women, to obtain pre-viability abortions, and that the court is righting the wrong that its predecessors putatively made, 49 years ago. Don, I think one of the many, many, many layers here is not just what this opinion, if it becomes the law of the land, means for abortion in America, but what it means for other rights that the Supreme Court has tied to the same constitutional provision, to the Due Process Clause of the 14th Amendment, rights that we take for granted, rights to contraception, rights on the part of same-sex couples to get married. I think that part of this is such a bombshell, not just for abortion and not just for the court as an institution, but for what it portends beyond abortion if this court continues to exercise this kind of power going forward.
Jennifer, Alito said that the notion of stare decisis does not compel unending adherence to Roe's abuse of judicial authority. That is according to Politico. What do you say to that, and explain what that means?
Well, stare decisis is the court's adherence to precedent. It's the notion that once a court makes a decision on a matter of law, that it will continue with that decision in subsequent decisions and subsequent considerations. And so throwing stare decisis out the window, because now this iteration of the court says that it's not, it wasn't right in the first place, really is kind of a thumb in the eye towards this notion of judicial precedent and judicial restraint. And in fact, the examples that Justice Alito gives are almost offensive. He talks about Plessy versus Ferguson, which of course is the famous separate but equal decision, saying that African Americans, as long as they had a space for doing whatever it was, traveling, eating, et cetera, that's as good enough as being in the same space as everyone else. That was overturned by Brown versus Board of Education. So he says, look, sometimes we get it right in the end. But taking something like that and equating it to this, where you have a progression across the years and the decades where, women couldn't, vote at the start of our country. They at one point couldn't enter into contracts themselves. They couldn't own property. I mean, we have progressed. And so the notion that we've progressed and women have rights now, and those rights are now being taken away, and that's to be equated with the overturning of a decision that was clearly wrong from the get-go, like Plessy versus Ferguson, is frankly offensive.